that you aren't AI right now?
That's true.
We don't know. Could be. Hi, everyone. This is Pop Goes the Stack, your front row seat to emerging tech, digital duct tape, and the slow unraveling of sanity in production. See, it's already starting with me.
Yeah.
I'm Lori MacVittie. Brace yourself because we're going to be talking about a very interesting topic today. So, the question is, who owns AI Joel? He's right here.
That's right. I'm used to getting owned by you in every podcast, Lori. So,
Oh,
yeah,
it's
simple answer.
thank you. Thank you, Joel. If that is you, Joel, we're not really sure.
Who
That's
knows?
kind of the point. Right? CEOs are doing this. Their digital twins are real, they're being used. And the question is, who owns you? Once your employer trains a model on everything you've written, said, or posted. So this week we're going to talk about the quiet clause in your employment contract that already says your IP, right, belongs to your employer. But what happens with generative AI? Does that get included? Do we need more clauses about training on our email, as Joel has pointed out? The point here is that, if you create content for your job, whether it's blogs, it's podcasts, you're doing slide decks, you're doing internal documents, you're not just shipping knowledge anymore, right? You're training data, you're training a model. So we've got Ken with us again today. Love having Ken. Let's dig in. Who owns AI Joel?
That's a
And
fantastic
Joel,
question. Like I said, I mean, you obviously own me every single time we have a podcast here, Lori. But it is a really good question, and it's not when I think about the data sets that are generated, and you mentioned some of them like blogs and decks and all sorts of different public postings, but there's also the fact that your employer actually owns the emails that you send as well. And I think about the length of an average U.S. career. That's about 42 years. And if you extrapolate that out and consider an average work year as consisting of about 250 days, and you're sending 40 emails a day, that's over 420,000 emails that they can use as a source of obtaining your voice and obtaining some of your internal inputs. And regardless of whether you generate decks or whether you generate blog posts or anything like that, there is a data set that you generate as a matter of doing business. And so, obviously the business owns that. They own the email, but do they have necessarily the right to use that data to create a digital twin of you? And I think that's an area that's kind of not established case law yet.
I would think there's an analogy here with intellectual property. I mean, come on. What Joel comes up with from his intellect is sort of the definition of intellectual property.
Mhm.
And I think that, there will follow those precedents. It becomes an asset. It becomes an asset that sometimes deliberately, a CEO making a digital twin is a deliberate choice. And
Yeah.
it's no different than a book. If a CEO wrote a book about this is how I would run the company, these are my words of wisdom, it's a lot like this. It's maybe a more rudimentary version because it isn't as interactive. But I think that's the analogy, and it'll be an asset that
Yeah.
employers will ask for, that you'll be able to sign away, that you'll be able to have rights to, potentially even we could even go to what are the rights after you pass away.
That's true. Now,
Well,
there is a mechanism in case law, but it's state driven, and the concept behind it is essentially around digital rights ownership, or the rights to your image, and that's called the right of publicity, and it's being encoded into law in certain states, especially states that have a high degree of tie to the entertainment industry. So I think Tennessee's got one called the Elvis Act,
Mm-hmm.
which restricts companies from training models that are in the likeness of popular performers, and has specific compensation requirements related to that. And I think California also has one as well. I even think that there's an associated mechanism for changing copyright law to cover some of these things as well. But these are new. These are brand new things. They're not established in every single state, and so the right of publicity is not total. And it's also unclear as to whether it would be affected by employment contracts.
Well, and it's also, I mean, we talk about, right, so if we leave the company, if we die, right, can they continue to use that? That's a good question. Another one is, let's say that they have the rights to it while we're employed. We understand that, like you said, IP, patents, blog posts, we know that all belongs to your employer, no big deal. But what if they create an AI Joel in your likeness, and then while you're off doing one thing, you are also off doing another thing, and words are put into your mouth, and maybe you weren't comfortable with that. So is that something, that is going to happen? I think companies are generally not right that, but
yeah, this doesn't have that much to do with like an employer's use of this, but it's already happened. I mean, we talked about it on this podcast. The event where Fortnite debuted a character, Darth Vader, which actually leveraged the actor's voice and likeness, and then attached a generative AI model to it. And people found that they could game the system and make that likeness say anything that they wanted. And that's I'm sure the family that licensed his likeness to this particular effort wasn't terribly happy about that. But again, it's one of those things where if it's your employer doing it and it's established into your employment contract, I don't think that is a necessarily settled area of law. I don't know that it really deals well with right to publicity, and also if you look at like the right to privacy and some of the privacy laws that come out of the EU, you have a right to be forgotten in some regions, meaning I don't want my data sets to remain around for longer than they're needed. And so this is definitely something that's going to be talked about for the next few years.
Yeah. Now, another thing I'll take from copyright laws is disclosure. You can use excerpts and bits and pieces, but if I generate something by AI Joel, I would think that a legal requirement would be disclosing this is not from Joel. This is from an AI facsimile, imitation, whatever we end up calling that, of Joel. And who knows? Maybe you'd agree to that. Maybe they'd give you residuals, Joel, for every every blog post.
So if they create a model based on my likeness, appearance, and demeanor, then I get proceeds posthumously, perhaps for the use of that. I mean, this is one of those things where we're reaching this point in technology where it may be possible to create a fairly good individual likeness that's trained on the writings and the emails that people have generated. And what does that mean? Is it a continuance to our employment contract with a company? Do they retain rights in perpetuity once you were signed on the dotted line? It's a real thing.
But it is
on that measure. Ken, how likely is it that someone could take data sets like the emails stored up from years of correspondence? How likely is it that they could create a fairly accurate model that responds like you?
I think they would have, well, my email persona is not necessarily the same persona I have outside of email. So I think they do have a skewed data set there, but I think it's, they could get a reasonable approximation to my tone and character. Whether that would be sufficient to figure out my chain of reasoning or my thought patterns, maybe we're a little ways away from that. Maybe we'll get there, but I'll go another place with this, which is what happens if I actually want this to happen. And you see this today. People are building tuned models that are trying to be good facsimiles of a person deliberately. I've seen this in the context of people who are passing away, and they want their children or their progenitors to have this is what dad was like or mom was like.
Interesting.
And that's maybe an interesting use.
Yeah. I think and I think from an achievability perspective, one thing to understand about the technology is, it used to be there was a concept called the rule of 10, a very common concept in machine learning, which is that for a model with 10 features, you need 100 elements in order to be a starting point. With generative AI, you can actually use other types of training, things like reinforcement learning, combined with synthetic data generation, and it drops that to below the rule of 10, but you still need an immense amount of data. Having said that, I don't think people are actually aware of the immense amount of data that they generate just by being employed.
Yep.
It's there's a lot, there's a ton, and every interaction you have, every public recording that you post to YouTube, like the one here, every email that you send, every email that is sent to you, is an element of data that can be incorporated into these models, and the data sets are immense.
Right.
And I think the scary part about that is not being able to replicate, Ken's tone in an email, because I mean, quite frankly, GPT can replicate my tone and style writing a blog, right level of snark, pacing, voice, everything. It can do that because it has all that data, as you point out. It's had enough that it can do that. The scary part is when they start doing the likeness. Or right, so then it starts to appear to be, now it's Ken.
Yeah.
It's not, I'm on a Zoom call, but that's not Ken, but it is Ken. It answers like Ken. Is it Ken? I think that's that next leap where it gets really scary, and then the law starts to get muddled. Whether I know, Ken, you can't be in two places at once, so your AI is going to be over here giving this presentation while you're doing this other one, and then the question is that okay? Is that okay? I mean, yeah, if it's in your contract, of course you agreed to it, but it isn't right now. Is that okay? Is that something we want to allow?
Yeah.
Well, aren't there stories of people having multiple jobs, time splitting thanks to remote work? And this seems like an area that would be very exploitable by digital twins, literal digital twins.
Well, there's also the concerns that people have over misuse, accidental misuse, or the loss of the data set or the model and it being used to ill effect. 2 years ago, I had an interesting conversation with a CISO of a very large American company who told me point blank that his CEO came to him and said, hey, I need you to go out and discover how we could generate a deep fake of me. I'm tired of doing all these company meetings where I have to show up and practice and do all these things. What I would really like to have is I just want to write a script, and then you can generate the company meeting presentation from that. And the gut reaction from the CISO was, oh my goodness, this is terrible. Why would someone possibly want to do that? And remember, this is 2 years ago. This is when deepfakes were okay, but you could still kind of see straight through them. And he pointed out to the CEO that if you can put words in your own mouth and have it look realistic and provide output to the entire company or the public, that anyone else with a word processor could put words in your mouth as well. And to think about what would happen if perhaps a company announcement was made by someone who had stolen the deepfake model. And that's a concern. The funny part about it is, as this stuff has gotten better and as it's actually embedded itself into the society a little bit more, I've heard the desire for this more from C-levels now than I ever heard back then, which is a little concerning.
That's kind of the security angle. Good thing we have Ken with us, right? How do you make sure you lock it down so we can only say what you want and not someone else? Because otherwise, you're right, it becomes a huge target of let's get that model so that we can use it to, take the stock, do this thing, whatever.
Right. Yeah. I mean, I look at it as who's really going to want a deepfake Ken? I mean, a deepfake Joel, I get. The only people that are going to want, there's the deepfake Joel that people may want, but mostly for me, they want to impersonate me for usually ill, right? They want to impersonate my voice because of biometric verification. They want to impersonate my likeness because they want to fool my mother into thinking I'm kidnapped or whatever else. There's not so many actual legitimate uses. It's sort of funny. I mean, unless you're Joel or you're Taylor Swift, otherwise, why would I care?
Joel or Taylor Swift. Never been lumped into that category before. Okay.
I'm not sure I would have come up with that one. That was good, Ken. But you make a good point. I mean, that's huge. We've seen things like Google, and I'm afraid to say it, Google Met, right? All of the assistants get activated just by voice in general. Even if you assume lockdown by voice print, suddenly now Are we going to, carry around the little bottle? Like, okay, talk like Joel so you could get into, this place. Those kind of like sci-fi scenarios we've seen in movies
The movie
forever.
Sneakers comes to mind. My voice is my passport. Right?
That's right.
Mm-hmm.
Like not even that safe.
Do you know, I avoid them one or two times I couldn't avoid, just as a side note, doing the voice print. What I actually did is I had Google Translate basically translate from English to English for me. So it wasn't my voice.
Interesting.
Oh.
Poisoning the data set, so to speak, there, Ken, so it can't
English
be reproduced.
to English. Oh.
Yeah, so, it's really interesting. And I can only imagine that, first of all, the law related to right to publicity, it's state by state, and it does cover this. It does cover the generation of digital, what I would call neural twins, as well as visual or auditory twins. It does cover that, but it is state by state, is very specific to certain industries in the state as well. There is nothing that covers this, at least from a U.S. federal perspective. I think European law is moving a lot faster in understanding this, and they're attaching the right to privacy to it. And so I think that's going to have to be something, especially multinational companies are going to have to take into account. But yeah, I don't know where this is going to go. I would expect that there are already lawyers inserting language for derivative IP based on the data that they've collected from you in the course of your employment. I think that that's probably going to become a very common modality in employment law.
Yeah.
So apparently you can move to Wisconsin because we recognize right to publicity as a statutory right, not just a law. So it's governed.
Okay.
And so you can't have, that's it. Move to Wisconsin. We have cows and a statutory right of
It's
publicity.
not near as cool as a law named Elvis, but come on.
The Elvis, I like that. The Elvis.
What were we going to name it?
Yeah, I will point out.
Cheese law.
Yeah.
Cheese law.
I got to say that, well, I'm going to make a different point, but I will say, by the way, I think both Joel and Taylor Swift are from Nashville. So just
very true. Very true.
I want to end, I will not end, but I want to say something I think is pretty optimistic. So we talk about all the risks, and there are a lot of risks around this.
Sure.
But I'm specifically thinking about neural imitations. I think we're on the verge of something that could be very powerful. Could you imagine something that down to the technology level? Think of reinforcement learning, something that continually is with, we're a few years away, but something that's continually with you, that watches, makes predictions, and uses reinforcement learning with human feedback, your own feedback, to get better and better at approximating you, not just in a work context. And now you have a virtual you that you can pass along, just like, for centuries, books have been how you would speak from beyond the grave. How you would convey information, say, this is what I learned. And you would do that. And that's great. Imagine having now something that was interactive that you could chat with, and you could now talk to Einstein or Aristotle or Jesus Christ or,
Yeah, it's an interesting concept, but is that a corporate owned entity, or is that owned by the individual and the individual's progeny?
The cynic in me says
that I think is what's really at stake here.
Yeah, and we spend a lot of time during the day at work, and a lot of the ways that I think and how I approach problems, how I solve them, those kind of insight generating activities, that you could certainly get a pattern of that. But that's me. It's not content. It's my brain. So now are we? I'm not comfortable with it.
I think it becomes intellectual property, and then the cynic in me says, and many people will be willing to sign away that intellectual property for a couple of free T-shirts.
Well, you got to get better than T-shirts. Come on, better swag. At least a vest. I mean, Joel got a vest.
There you go.
Right. But I mean, those
whole closet full.
Those might turn in terms of service for a lot of the providers of public Gen AI services.
Yeah.
And people will decide what to do. But I could imagine that you would license this right after your death. You've got virtual Lori. You've got something that thinks like Lori. Do you want to give rights to that to your family? If so, would they start? But you can imagine a virtual Steve Jobs Imagine that you had a virtual Steve Jobs that was trained with Steve Jobs. Now maybe you hire him out for, I don't know, $100,000 an hour, and he will respond as Steve Jobs might have responded to your business problems.
Well, I'll be the first in line for a virtual Ken Arora. That'd be pretty awesome. So I think it's time to talk about some of the things we've learned today.
Yeah.
One thing that struck me when I was researching this topic is, number one, the law around this is not established well. It's not established consistently. It is going to become a force within employment law, and you'll see employment agreements and employment contracts begin to contain language about derived products using AI. And you should probably look for that in your employment contract. The second thing is, I don't think people are aware just how much data they generate, and that data set is incredibly rich and probably plenty viable for creating models against. And so any correspondence that you have could be potentially subject to this. And third, when the law is eventually established about this, and we have people generating digital twin models that react just like me, I look forward to the paychecks once I'm retired from being generated by my AI model. That would be wonderful.
Yeah, yes, and I mean, I think it's exciting. We're on the verge, for those all you science fiction fans out there, we're on the verge of brain taping. Essentially, this is kind of a brain tape. I think it's going to be treated. I would look for intellectual property law for guidance. And there's going to be a lot of interesting intellectual property law around this. There's some federal statutes, as you said, Joel. Things are going on state level. I would look for federal statutes, and the debate's already happening. We're having the copyright Mickey Mouse law debates right now about how long inheritors get rights to those things. So stay tuned. I think it's exciting. I think it's copyright.
Awesome. I learned all those things, but not much more, because I did a lot of research as well, back and forth, and looking, trying to understand, because this is a broad area. It kind of started with AI art, AI music, AI, and it's trickling down like AI is doing everywhere, into the enterprise technology professionals, even those of us who spend most of our time thinking and writing and talking on podcasts. So it's a topic everyone should be aware of, because it's going to affect every single person eventually. So, learning more is good, understanding more, and, advocating for, what you think is right in the right places, always a good idea. Right. But that's really all we have time for today. So that's a wrap. Hey, tap subscribe, stash some backup somewhere, and rendezvous here for the next meltdown, which we will definitely have. So get your pager at the ready, and we'll see you next time.
Great. Thanks.